Hello.
Hello.
I just want to test my mic.
Oh, okay. No, that's fine. It's
All right, it's working. Thank you. Zubande, I'm just
Hello.
testing. I'm just testing
Hello.
my head.
Hello.
Hello. Okay, good. I'm just testing my headphone. I can hear you. Thank
Hello.
you. Hello.
Yes.
All right. I'm
Consummate.
just testing my headphones. I just want to see if I could hear you. Thank
Oh,
you.
okay. Okay. Thank you.
Thank you.
Morning, Mr. Angelini. I'm just checking if I'm audible.
Morning, Chairperson. You are?
Great. Okay, we'll just wait another 4 minutes and then we'll start the meeting. Thanks.
Thank you, Chair.
Recording in progress.
Great. Good morning, all, and you are very welcome at this meeting of the Department of the Select Committee of Public Works and Infrastructure, where we will today receive a briefing by the Department of Public Works and Infrastructure on the findings and recommendations of the investigation conducted by PricewaterhouseCoopers into the pressure swing absorption oxygen plant tender awarded by the Independent Development Trust. First of all, let me welcome, I see Minister McPherson is online. Very welcome, Minister. And I've received a delegation list from the Department of Public Works and Infrastructure. So welcome, Mr. Mtombeni. And also from the IDT, if the IDT board chairperson is online yet, Ms. Mbini Hill, you're very, very welcome. We are going to go through the formal introductions just now. Honourable members, the agenda this morning, and greetings to you all as well, will be as follows. Thank you very much, Mr. Angelini. We will start with after the introductions by the committee and the department, we will start with a briefing. The briefing will take place from around about 10:20 till about 11 o'clock. So we'll give 40 minutes for the department for the briefing. We will try and be a little bit more lenient with the time if they run over time. We will then do deliberations between ourselves and the department from 11 o'clock till around about 12:40. And then we will excuse the department, and we will have some minutes to address of previous meetings, and we will close the meeting just before 1 o'clock. Members, can I please get, honorable members, please get from one of you a proposal for the agenda?
Chairperson, I propose is Honorable Skiergogel here.
Thank you very much. Can I have a seconder, please?
Andra Peter support. Thank you, Chair.
Thank you very much, Honorable Peter. Mr. Ntelini, are there any apologies?
Yes, Chairperson. Good morning, Chair and honorable members, the Minister, officials from the department, and fellow colleagues. The apologies that we have received are two. It's Honorable Kaunda, who's not well, and Honorable Briette. She's still busy with the exams.
Thank you very much, Mr. Ntelini. Let us then go over to introductions. My name is Rikus Baardhorst. I'm a permanent delegate from the Western Cape. Let's go to Honorable Skiergogel.
Good morning, Chairperson. My name is Igor Skiergogel. I'm a permanent delegate from the Free State.
Honorable Peter.
Good morning, Honorable Chair. My name is Mandla Peter, a permanent delegate from Eastern Cape.
Thank you. Our Chief Whip, Honorable Moimang.
Good morning, Chairperson. My name is Kenny Mwimba, a permanent delegate from Northern Cape. Thank you.
Thank you very much. I see Honorable Nzamande.
Good morning, members. Good morning, Chair. Good morning, the department. My name is Jabulani Nzimande, a permanent delegate from Gauteng.
Thank you very much. I see Honorable Molokome, our committee whip.
Good morning, Chair. My name is Regina Molokome, permanent delegate from Limpopo Province. Thank you very much.
Thank you. I don't see any other members. Honorable Makasini, Honorable Treza, are they online? I see Honorable Mbebo. You're welcome to introduce yourself.
Good morning, Honorable Chairperson. It's Honorable Mabebu here from the Northwest Province. Thank you very much.
Thank you very much. I don't see Honorable Treza or Honorable Makasini online yet. Thank you for that. As I said earlier, you're very welcome to our meeting this morning. Honorable Minister McPherson, would you like to hand over, and I'd like to hand over to you to do your introductions, please.
Thank you very much, Chairperson of the Select Committee and honourable members. It's great to be with you for a second week in a row. I'm really grateful for the opportunity. And again, let me commend the committee for being willing and able to plan with my office for me to be here. It's much appreciated. And again, I really enjoy the conducive environment in your committee to be able to deal with important issues. Chairperson, I will ask our DDG for the IGR to please introduce our delegation. We have, and of course, we then also have our chair of the board, Ms. Hill. So I will ask just him to do so because we are virtual. I don't have the full list with me. Through you, Mr. Mtembeni.
Thank you.
Thank you, Honorable Minister. Good morning to Honorable Chair and Honorable members. From the side of the department, in terms of our delegation, I've been requested to lead the delegation as a DDG for IGR, representing our DG, Mr. Sfiso Mdakane, who's attending the portfolio committee on the sidelines. So with me from the side of the department, it will be the DDG for GRC, Mr. Loaz Mahlangu, who will be leading the presentation. I also have from our legal services, Mr. Christopher Mahoba. So he'll be here joining us, and also having the head of communications, Mr. Lennox Mabasa. So this is the delegation that we have, Honorable Chair, from the side of the department. I'll leave it to the chairperson of IDT board to take us through the delegation from their side. Thank you so much.
Thank you, Ms. Hill. You're welcome to continue. Anyone else of the board members?
Is she? I can see someone from the IDT, but I don't know if that's her. Adam, could you just see where Ms. Hill is, please? I see someone from the IDT, but I don't see the chair.
Good morning, Minister. My understanding
Yes.
is that
Derek.
the chair did apologize for this meeting, and both Matosi and I were then delegated to attend this meeting. I'm Derek Naidu. I'm the chair of the HR and M committee and a member of the board. Thank you very much for having us. Thank you.
Great. Thank you very much for those introductions, and you're very welcome, Mr. Naidu. Thank you very much, Mr. Ntumbeni. Honorable members, before we go on to the actual presentation, I think let me just start off by saying that today's meeting deals with a matter of great public importance. The forensic investigation into this pressure swing adsorption oxygen plant tender managed by the IDT on behalf of the Department of Health is an extremely important function. The Select Committee welcomes the Department of Public Works and Infrastructure and the investigators for their presentation on the findings and recommendations arising from this report. Our interest in this matter is rooted in accountability, transparency, and integrity of public procurement. As I said earlier, the PSA oxygen project, which is valued at over 800 million rand, was intended to deliver life-saving services, ensuring that hospitals across the country have reliable oxygen supply, particularly in rural and under-resourced areas. And yet, allegations that surfaced in 2024 of irregular appointments, inflated costs, and non-compliance of the South Africa Health Professional Regulatory Authority's requirements raise serious questions about governance within the IDT and the stewardship of the public funds. So we note from the report that disciplinary and criminal processes have been initiated, and that the CEO has been suspended, and that the matter has been referred to the Hawks. And I want to congratulate the Minister, McPherson, and your department for a swift response, which needs acknowledgement. However, our task as a committee is not merely to receive the report, it's also to ensure that systemic weaknesses are addressed and that corrective measures are sustained, and that public trust in state implementing agents is restored. So, as a committee, honourable members, let us therefore approach today's briefing with a firm but fair spirit of continued oversight, mindful not to compromise ongoing investigations. Honourable members, I will then ask you, when it comes to the engagement time, to please bear in mind that the investigation is still ongoing, and that some of the questions might not be able to be answered by the department without compromising the ongoing investigation. Just be aware of that as well, please. And let's then ensure that accountability is pursued to its fullest extent. So with that, I'd like to hand over to the Minister for his introductory remarks, and then we can go on to the presentation. Thank you very much, Minister. So, Minister, I think you're on mute.
Sorry, I'm just trying to work between two screens. So, but thank you very much, Chairperson. Thank you again for your welcome to the members of the Select Committee again, and all officials present and members of the board. Let me thank you for the opportunity to present the findings and the progress relating to the oxygen plant tender. It also underscores the seriousness to which we, certainly within Public Works, take allegations of maladministration, fraud and corruption, managed not only by any of our entities, but also within our department. And I think that this is an important and painful process that we've had to go through, but a necessary one that matches our tough talk with tough action. For us, chairperson and members of the committee, transparency, accountability, and consequence management are non-negotiable in our department. The presentation that we seek to provide to you today relates to an independent investigation that I commissioned when the allegations were first launched in the media, that raised a number of serious red flags about tender irregularities, including the appointment of unqualified contractors. I was left with no choice but to ensure that an independent forensic probe was launched, which was then ultimately undertaken by PwC. Just some background, chairperson and honourable members, as it has been some time. You'll recall that a report first alleged that a company called Bulking, that had lacked South African Health Products Regulatory Authority, which is a requirement and accreditation for any business that provides medical services, had been awarded a contract of nearly R500 million to install oxygen plants in public hospitals, and that the award process had been influenced and possibly irregular. I, at the time, engaged with the then Executive Authority and Board of the IDT to ensure that we were able to get to the bottom of it. Unfortunately, there was a reluctance to do so. At one point, there was even a suggestion that they would investigate it themselves, which obviously, given the serious allegations, was not palatable to myself. And on that basis, I launched the investigation. The scope that we included was to review the appointment process for all of the external providers, to determine whether relevant laws, procurement policies, and guidelines were adhered to, and to assess whether the service providers were qualified and capable of performing the work, and also to identify any officials or external actors which may have caused irregular, fruitless, or wasteful expenditure, and to establish whether there was any evidence of fraud or corruption, and recommending disciplinary, civil, or criminal investigation. Chairperson, as you will see in the report, which I will allow the committee to do, which I will allow the department and board to present, is that there were indeed serious and fundamental failures within the processes to award that contract. That the companies that were, or at least the one company that was awarded to do so, did not have SAPRA compliance to do so, and did not have qualifications by the CRDB to be awarded nearly R500 million when they were only qualified to be awarded 200 million rand. The composition of the bid specification committees and bid evaluation committees were also found to be irregular, as Department of Health officials who were meant to act only as observers had been improperly included as members in violation of the Memorandum of Understanding signed between the suspended CEO and Director General of the Department of Health. If you also look at the expanded findings, Chairperson, you'll see that the original project budget had been expanded from 216 million rand to 592 million rand, which was a 174% increase, and then even went up further to the 800 million rand. Chair, of course, this report is the subject of internal HR processes as they relate to the officials involved. It is also with the Hawks as well, and I understand that a decision from the Hawks is imminent. on possible prosecutions. This investigation by the Hawks in fact predates our investigation, and this has actually supplemented the Hawks investigation. So you will appreciate, and thank you, Chair, for noting that there is a level of sensitivity that we have to approach this with, because I'm absolutely determined to secure convictions and to ensure that those that are accused of wrongdoing do face consequences. I think it would be a travesty if we were to shortcut that process for expediency and then to see them walk off scot-free. I think that the public expect us to deliver verdicts on these allegations, and therefore we must follow legal advice and HR processes to do so. So, Chair, to answer your question, indeed, we have learned from this, and there are a number of recommendations that the report makes with regards to supply chain management and internal controls, which we are following, that the board is following. I should also add, Chairperson, that through the Minister of Health, that they have asked us to expand the work of the PwC investigation to also ensure that we can then provide them with further information as it results to health officials so that they can also follow a similar process. And I'm very grateful to Minister Motsoaledi for his support and engagement in this process. So that is also a further reason why we do need to protect the sanctity of this reporting process to ensure that on every level we are able to demand and deliver accountability. So, Chairperson, let me again thank you for the opportunity. I'll hand over to Mr. Mahlangu, the DDG for Governance, Risk and Compliance, to present the high-level findings to the committee. And then I'm sure we'll hear from the board, and then we look forward to the questions from the committee. Thank you so much.
Thank you, Honourable Minister. Mr. Mahlangu, you're welcome to continue.
Thank you, Chair. Thank you, Minister, and good morning, Chairperson, Honourable Chair, and members of the Select Committee, colleagues from the department, as well as trustees and executives of IDT. Chair, just to take you through the presentation, most of the stuff has been covered by the Minister, but suffice to say, just to highlight a few things as well, in addition to the presentation made by the Minister, opening remarks. If we can go to the next slide, please, I appreciate. Again, that's the background that the Minister gave in terms of the allegations that were made in the media. Next slide. And also the concerns that were raised about the ghost company, that also affected the procurement and the entire project, but also some areas of scope, as well as specifications that were embedded into the memorandum of agreement between the Department of Health and IDT, which also included the service providers having to have been accredited with the SAPRA certificate. That was also an issue that was raised around the accreditation, particularly given the fact that you are operating in the space of health and medical products that also needed to have this certificate. Next slide. And then also the concerns were raised about the existence of this company from the issues of address, the directors, as well as whether the company had the right credentials for this project. And then owing to these issues, then the Minister commissioned this investigation. And through our internal processes, from an independent point of view, and also from a accountability, as Minister exercises this oversight over the entities, and also to satisfy himself with the independence and credibility of the investigation. Through our internal processes, we then looked at our panel of service providers to assist with the investigation, which in this case, PricewaterhouseCoopers was then appointed to then look at these allegations that were in the media. But beyond allegations was to say, because it's an entity of the state, in this case, the entity of the Department of Public Works, we also need to look at the internal processes that were followed, as well as also a reputational issue of the entity, given its contribution as well as its role with regards to social infrastructure. Next slide. Then the minister also alluded to this, but just to break it down in terms of the scope, is that, again, now when you link that to the allegations that were expressed in the media and then the scoping, you'll see that the main issue was around the irregularities in the appointment of the external service providers. So the investigation sought to then test the procurement process of this project from the memorandum of understanding, to the processes that were followed, 3, all the bidders that were involved in the process, 4, the pre-selection of the bidders, and 5, the administration of the contract itself, up until the point of which this was then terminated owing to these findings of the investigations. Next slide. So again, the consideration as that also assisted in terms of this investigation, if you look at the administration of the tender, appointment of service providers, management of service provider contracts, and also whether the service providers adequately performed these duties, including the conduct of the officials who were involved in this. Now, by officials, we basically mean that those that were part of the procurement process within the IDT, but we also had those who were from the Department of Health who also participated in the process, which I will also come to it in terms of the findings. And then overall, we're also looking at the entire procurement process, and the main issues that we considered were in the terms of this scope would be the regulatory documents that were also part of the investigation. Look from the Constitution, Section 217 of the Constitution. Look at the PFMA sections that relate to the procurement. The investigation also looked at the preferential procurement policies. There were also National Treasury SCM instruction notes, particularly the ones that relate to prevention and combating abuse in SCM systems. And then you also look at internal in the IDT, what were the IDT internal SCM policies that then governed the administration or the conduct of the officials, as well as the process of procurement within IDT, as well as delegation of authority, because we're talking about significant amounts, as well as whether they had delegated authority to actually move ahead with this procurement. So those are some of the areas, those are some of the regulatory documents that were considered in terms of this. Next slide, please. And then determining the extent of any irregular or illegal activity and the involvement of officials, external service providers in relation to the scope. We also looked into that. If there's any possible fraud or corruption in respect to the procurement, as well as contract management, to the extent of affecting service delivery. And then the intention also as part of the investigation is to ensure that the evidence that's collected is also admissible in the court of law, and also that is also used, as Minister highlighted, in terms of consequence management, to institute disciplinary or civil or criminal charges against or any who will be implicated as part of the investigation or implicated in this process. And then again, because we talk about irregularities in the procurement, and again, looking at IDT policies, IDT SCM policies, IDT code of conduct, IDT delegations of authority, we sought also to look at what will be the recourse or recommendations or course of action to also improve the procurement processes within IDT to ensure that we do not have the occurrence of this as well. Next slide. Now, the findings in a nutshell, basically, in threefold. One, we just looked at the flawed procurement process. Two, we're also going to look at the process. Two, we're also looking at the expansion of scope. And then three, we're also looking at the changes in terms of so not the changes, the certification, the requirements, SAPRA requirements, as well as conflict, or rather the requirements of the prescript, the National Treasury prescript that determines prevention and combating abuse in SEM. We'll also look into that when we get into the findings. Now, just by way of some form of timelines, so that there's an understanding of this memorandum of agreement, which was signed by the Department of Health and IDT in 2022, is that. So from 2022, June 2022, up until July 2023, you'll see that there will be a memorandum of understanding of agreement that was signed between Health and IDT, which was valid for a period of 5 years. Now, that memorandum of agreement also had what we call the IPIP, infrastructure procurement, as well as improvement plan, which was also approved by the Department of Health. This is part of the procedure or processes or requirements when you're dealing with large infrastructure, which was signed by the Department of Health. And then in the process after this IPIP, then there was also an appointment of a professional service provider. In this case, was appointed for the PSC for this project to also determine the rates of professional services that will be charged. And then the closing date for this was around February 2023. Now, at the close of this, there were 61 bidders. 61 bidders responded. But the pre-selection of this process resulted in only 8 who were deemed to have qualified with regards to the requirements of this project. Now, those 8 bidders were then pre-selected to look at about 60 facilities, hospital facilities, to roll out this PSA oxygen plant. Now, the service providers that were appointed were, however, not required to provide evidence to meet the SAPRA requirements. Now, there's a distinction between the memorandum of agreement and the process of RFQ, the request for. Now, the RFQ, request for quotations, meant basically that the requirement of or the SAPRA was actually a requirement as per the memorandum of agreement. And for some reason, in the terms of the procurement process, a request for quotations, which resulted in 61 bidders, as well as the pre-selection of the 8, this then fell off, which means that already there was an irregularity in terms of the procurement process in relation to the memorandum of agreement of having the SAPRA certificate as a requirement for this project. Next slide. So, yes. So again, it therefore appears, we say appears because but when we look at the memorandum and the RFQ and the entire value chain, that the service providers for the rollout of this, well, we actually appointed without confirming any of the appointment service provider in terms of meeting this requirement of providing the SAPRA certificate. Towards the end, I'm going to also flag out this issue honorable members and chair, of why we say it appears and then why it eventually became an irregularity in relation to a procurement process. Again, the SAPRA license was not included as mandatory in the RFQ, as I highlighted. And then bulking, which was one of the, again, go back to the media, it was deemed to be a ghost company, or was alleged to be a ghost company without any directors, addresses, and websites, was one of the preferred service providers. Again, it also became part of the, out of the 61, the pre-selected, the eight pre-selected bidders, who also did not have the required authorization, but bulking used a SAPRA license of another company called Atlas, and then therefore, as part of their submission. I'll come to the as well as why we then say it appears and why we say it's an irregularity. Now, when you look at the timelines from a procurement process, again, is that the Atlas Corpco's SAPRA license that was then used for bulking, it came after the close of the procurement, the due date, the deadline. So there was an engagement after the close, and therefore it was provided. So which means that there was an irregularity in the context of the provision of the required documentation that was detailed in the memorandum of agreement. But again, when you say the RFQ did not mandatorily specify the RFQ, and then the question you'll ask is, why then was it provided after the close of the tender, days after the close of the tender? Which means that ideally, it was now trying to regularize what was in the memorandum of agreement, but at the time of the RFQ, it was not detailed as such. And therefore, we say that was also an irregularity in terms of the procurement processes of... right, next slide. So again, here we're saying the criteria that was used should have included the SAPRA in terms of the RFQ, as well as all panel members or all those that have the bidders ought to have submitted this as part of the entire process. And as a result, the RFQ that went out, which was did not spell out the SAPRA, then meant that the entire process, therefore the entire process would have been irregular if then we deviate from the memorandum of agreement 1, 2, where it's stipulated even in the IPIP that because we're operating into an environment where it has health and medical products, that certificate is mandatory, and therefore it becomes irregular if then the bidders do not provide that. And worse still, if then the identified and one of the service providers who has been appointed and awarded provided a license belonging to another company after the close of the procurement process, that then also is deemed as irregular. Now, when you go into the minutes as well of the specification committee, as well as the evaluation committee and the management adjudication committee, it was found also that the minutes were vague when you look at the contents, the discussions and the decisions that were taken, and then contained limited information relating to this project. And that also created a challenge in terms of following through the understanding and the logic in relation to the procurement processes, because that also needed to be tested against those regulatory documents in terms of the Constitution, whether they followed the Constitution, Section 217, whether it followed the PFMA, and also the instructions, National Treasury instructions, and also whether it followed their internal IDT delegations as well as prescripts, SCM prescripts. So that limitation also resulted in proving this to have a number of gaps and eventually an irregular process or challenges within the procurement process. The second aspect as well with regards to the composition of the committees themselves is that The BSc and the BSc for evaluation of these RFQs was also irregular in terms of its setup, in the sense that from the memorandum of agreement, that 2 officials from the Department of Health were appointed as observers in this procurement process, as per the MOA between the 2 entities, between IDT and N. However, when you look at the minutes as well as the decisions that were taken, they became voting or fully fledged members of the committees, which means that they had made decisions and then relinquished that observer status, and they became part of that. That is also an irregular aspect of it that was right, that we raised. And you see that towards the end, when we're also looking at the consequence management or the engagement between the Department of Health and the Department of Public Works as an extension of the investigation, is also saying to the Department of Health they must also look into their own members who participated in this process as part of the consequence management causing this irregularity. Next slide. Then when it comes to the PSP, which is a professional service that I alluded to in terms of the process, and Minister also raised this issue that from the allocation it was meant to have started at 216, but eventually became a large amount. We also found that the investigation finds that from a design point of view, at the tender stage, the initial price was 216. But it was also and then the design stage was 253. However, when you look at this, there was a high amount after the assessment came to, and then that high amount came to about 592.6 million, which then the Department of Health requested for an approval for the rollover of this project as well. So that's a significant increase as well. Now, when you look at that increase from 216 to 592, that translates to about 174% increase from the initial estimate of the project itself. So that's a high increase as well. Now we're going to come to the findings of what does that translate to in terms of the National Treasury's prescripts when it comes to the 25% of local content, as well as subcontracting aspects of the prescripts as well. Next slide. The Balkan company, again alleged in the media to be a ghost company, which also was part of the 61 that tendered and then became the part of the 8 that was pre-selected, did not have the SAPRA, as we said, that they used the other company, was also allocated a large chunk of the oxygen plants. Out of the 60, they were allocated about 45 facilities, which amounted to 428, compared to the second service provider that was allocated, Mazia, that had a SAPRA accreditation, was awarded about 10 facilities to the tune of 152. Now, what does it mean in terms of this? Now, Balkan was awarded a large number of sites, 45, and again, when you look at the CIDB grading threshold of Balkan in terms, Balkan had a threshold for you to have a threshold above in terms of the allocation. Balkan was CIDB grade, we're seeing in terms of the CIDB grading had a threshold of about 200 million. So which means that you ought to have been allocated facilities below, up to 200 million or below. But in terms of the final, they were allocated 45 sites, 45 facilities up to 428 million. Now, when you look at the difference between 428 and the 200 of the threshold, again, in terms of the national prescripts, National Treasury prescripts, is that 25%, there was about over 25% of subcontracting by Balkan. And the question then arises, what then was the role of Balkan in executing this if against the prescript that you, from a subcontracting point of view, it must subcontract up to about 25%, but the difference was more than 25%, and that was not even disclosed, further violating the procurement regulation with regards to that 25%. Because when you look at the comparison, the amount is way above 25% of a subcontracting, and that then questions the principal bidder versus the subcontracting amount of it as well, amount and the threshold. Next slide. So that disproportionate allocation as well also contributed to irregularities, and the failure to disclose the subcontracting above 25% also resulted in an irregular and a violation of the procurement prescripts. Now, in terms of consequence management, what is the investigation proposing in relation to the procurement process? 2, the officials that were involved, and then 3, the disproportionate as well as the amounts. 1 is the IDT leadership, senior management and supply chain management, especially those that participated as committees where the disciplinary actions has been recommended to them. I think these processes are still unfolding. And then the presentation also makes systemic recommendations in relation to the entire procurement process. One is a continuous IDT training of members that are involved in the SEM in relation to 1, the composition of the committees in relation to 1, IDT prescripts, IDT delegations, National Treasury prescripts, as well as conforming to the Constitution, Section 217 of the Constitution with regards to procurement. Secondly, was to look at the procedures to ensure proper minute taking. Again, we identified that the investigation identified proper record keeping, vague minute taking, which then also affected the understanding of the decision that also led to the appointment of these service providers. So proper record keeping is also a systemic issue that was recommended to ensure that there is there is proper record keeping as well as follow through of the decisions that are taken by the BSC members. Next slide. And then post-investigation, right? That is the first. So the investigation will be two legs. So there's the primary investigation, which basically is what that also minister also took made reference to say primary investigation, and there was a media statement that was released as well, and the issues were more around the governance and accountability and the procurement irregularities that were identified. Then post-investigation is to then say, now that there is a primary investigation has been concluded and there were allegations made and the allegations were investigated, and these are the findings of the allegation of those allegations, or this is what was found in relation to those allegations, then you engage into a next level. In this case is to test those that are involved in this and also to action that will be taken. And the first action basically was to then suspend the CEO on the basis of the findings of the primary investigation, but also get also the other employees to make representations through the labor relations processes to submit written representations. That's a process that is still unfolding, and also engage the employee relations to complete and review that will then review their submissions and will make a determination on what consequence measures will be taken, whether corrective or progressive consequence management. But further to that, the matter was also referred to the Hawks for criminal investigation, and also Minister has engaged internally in the department to engage with the Minister of Health to broaden the investigation. A letter was written to Minister of Health, who also requested that because there were also colleagues from the department, including the decision that would have been made by the accounting officers, would also want to expand this so that there's a deeper meaning, deeper understanding of the entire value chain within this process. That process is still also unfolding. And then from a project point of view itself, it was terminated in terms of IDT being the implementing body, and then has since been ceded to DBSA for a full execution and implementation. This is now an engagement between the Department of Health with DBSA for further project management of this, while the internal processes of representation as well as consequence management unfold, or disciplinary hearings, if you will, unfold. So these are some of the issues that are basically happening, taking place from the post-engagement. And I think at the time, through the ministers, at the minister's discretion, will then advise on the post investigation with regards to the public, so these are basically high level findings of the primary investigation with regards to irregularities procurement, the colleagues that officials that were involved, as well as the allegations around the bulking company, which did not qualify in relation to the allocation of those sites, disproportionate allocation of the sites against the CITP threshold, as well as the requirements of that SAPRA licensing that was also issued. That then points to a number of violations to SCM procurements, as well as one would argue deliberate intention or intention to circumvent these procurement processes. We'll therefore request the Select Committee to note these findings, and also they note the status of the post-investigation process undertaken by the department thus far. Thank you. Thank you, Chair.
Thank you very much, Mr. Mahlangu. DDG Mtombeni or Minister, are there any further inputs from yourselves or from the board members with the IDT before we go over to the deliberations?
Chairperson, thank you. Through you, I'd like to hand over to our colleagues, the board members. They're actually the two ministerial members, so they're appointed by myself to the board. If they would like to say anything on behalf of the board, also they are, Derek is handling the HR committee and Matotsi is handling the legal side of the board. So they may want to say something now, or be called on to respond to any questions by the committee. But let me hand over to Mr. Naidu. Derek.
Honourable Minister, thank you very much for the opportunity. I think the presenter has summarised the actions taken by the board, and I merely want to confirm that that is so. The legal processes are proceeding, and we will take questions as the committee would deem fit. I just want to, at this point, just indicate that we do have present the acting CEO of the IDT, Sifiso Nzibande. We have also the corporate services unit executive, responsible also for HR, Bangile Nene, and we have the CFO, Mr. Londozo, also present here. They will also assist in answering questions that might be fielded by members. Thank you very much.
Thank you very much, Honourable Minister. If there's nothing further from you.
I think that's it from us, Chairperson. We eagerly await the questions. Thank you.
Great. Thank you very much. Honourable members, it's now your turn for engagements. I'll take hands and let us follow the normal 3-minute rule and see if we can work around the room, the virtual room, more than once. So let's try and keep our questions to questions and limit the statements. We'll start with Honourable. I see that Honourable Makasini has also joined us in the meanwhile. You're welcome, Honourable Makasini. Let's start with Honourable Nzimande. Your hand was up first.
Thank you, Chairperson. Now my questions are as follows. Firstly, the first question, what was the rationale of using PricewaterhouseCoopers against the background it has in relation to Steinhoff, SAA, and ESCOM, in terms of flawed kind of findings? This obviously is informed also with the next question. Next question is the department implying that those that were asked to give representation, employees that were on suspension, that were cleared, is it implying that the department also has some doubts in terms of the accuracy of the information contained in PricewaterhouseCoopers findings? That's not another aspect. The other question that I have, Chair, is in relation to the department suggesting that there should be training of BSc, BC, and BA. Is that not necessarily mitigating against the serious sanction that these workers must be facing? Because it's like the department is implying that there is a gap in terms of abilities. That's why then they want to augment it through training. Then the last part that I have as a question in this round, it's in relation to the issue between the two departments. One is that I see the recommendation is saying discipline be confined to IDT, including the CO that has been suspended. But what is unclear is how the referral was made to Department of Health to deal with the issue of discipline. And lastly is why really are we repeating what we have done in NA, just to give a summary and not disclose the full information in relation to all the affected companies or bidders or service providers? Why the department is doing the very same thing, that you come with a summarized version? Thank you.
Thank you, Honourable Nzimande. Honourable Peter, do you want to ask your questions as well? I've noted your request in the chat, Honourable Malakome. We'll get to you. Honourable members, if any of you are not able to raise your hands due to your gadget's limitations, just indicate in the chat and I will recognize you there. Honourable Peter, over to you.
Thank you, Chair. I don't know whether I'm audible or visible.
You are audible and visible.
Thank you so much, Chair. Chair, mine is to check from the department, due to the fact that administration after administration come and go, and the department remained. Now, mine is to check from the department representatives who are present now, Chair, that how long does this panel has been working for this department? That is my first question.
You've just gone on mute as you started presenting your question. So if you can just retrace your steps.
Let me check it. What is happening now?
Yeah, you are now audible, yeah.
I'm audible now. All right.
Yes.
I was trying to check that administration after administration come and go, and the department remain permanent. Now, my question is, Chair, to check from the department who are present now in this house, that how long does this panel has been working for this department, the panel that are present now. Secondly, the question that are asked by this select committee, are they new to their ears as the department point of view, or does they add value? If are not new or add value, what impact do you think as the department will bring changes from this department? Lastly, ministers who come and go doesn't prohibit your department not to achieve what the department is supposed to achieve due to policy changes or political instability. What prohibits your department not to achieve what they're supposed to achieve? I thank you, Chair.
Thank you, Honourable Peter. I think, Honourable Minister, let's go over and take Honourable Nzimande's, Honourable Peter's questions, and then we'll return to the rest of the questions. Thank you. Honourable Minister, over to you for those two sets of questions.
Sorry, I apologize. I thought that there were more there. Thank you. Let me start off with Honourable Nzimande. We work on a competitive bid process. I don't appoint companies to do work for the department. That is done through the Directorate of the GRC. I think that from the report that I've seen, I can tell you that the PwC report is exhaustive, it's extensive, and it deals with the issues that were before it in a legal and factual basis. I can't comment on what they have or haven't done previously. I can only reflect on the work that they've done for us in this instance, and the work that they've done, I can say, is really good. The report, as I understand, is accurate. It has made findings against a number of individuals that then need to be dealt with either through a criminal investigation or a HR investigation, which is currently what is underway. Let me just say that, as the department, our job is, in Latin, they would say functus officio, which means it's come to a conclusion as the department. So we do not instruct the board. That would be irregular for me to instruct the board of how it conducts its processes going forward. That report was handed over to them to deal with in terms of the recommendations that came out of it. And if anyone gets cleared, it will be cleared through a process led by the IDT or the South African Police Services. I think that what the recommendations regarding training or intense focus in SCM is clear that a lot was to be desired around how SCM processes are undertaken at the IDT. That's why I had suggested to the board that all supply chain management awards under the suspended CEO should be looked at, because it's very clear that that there is a massive problem with regards to supply chain management. Now, supply chain management, Honourable Nzimande, has become the ground zero for where corruption starts. It's where tenders are shaped to suit certain people. It's where awards are made to people that shouldn't have got them to begin with. And it's why we have taken such a strong stance as a department to get our department's SCM process and our entities right. And on the 1st of January, our new DDG for SCM will be starting, Ms. Lorraine Nadu, who comes from Transnet and the KwaZulu-Natal Department of Treasury, National Department of Treasury, so that we can actually make sure that we have adequate processes in the department and across our entities. And I think that even as a department, we can learn. We must always be learning from when recommendations come out around supply chain management about how we can improve our processes. I can't instruct the Department of Health, Honorable Nzimande, what to do or not to do with their officials. I've had a discussion with Minister Motsoaledi, who, as I said, has been very supportive of the process that we've undertaken and been a great help and resource. And through our GRC has asked that we now expand that probe so that that there is sufficient and complete evidence that can be used on the department side. Remember, our scope was only to look into what had gone on the IDT side, not necessarily the health side. So that will be taking place. Honorable Nzimande, I think I have answered this question previously, but I think it's important to do so again, because if we were to put the report out today, and we just released it as it is, all of those officials who are being investigated, either by the Hawks or by the IDT, would effectively be able to walk off scot-free. And correctly so, members of parliament and the public would then hold me accountable for that. Now, we have been implored by the law enforcement agencies of this country not to do so, because it would jeopardize the case that they placed before the courts. And I think that we need to, be frank and honest. What is it that we want? Do we want people to be held accountable? And if so, then this is the process that we need to follow. And as soon as that process is complete, we are then able to put all the evidence in the public domain. Or do we want to jeopardize that and see people walk off scot-free? I would hope that people would take the path of saying, let's ensure that people are held accountable. So I have to take the advice of law enforcement agencies, of our legal professionals, that say that we must follow this process in order to ensure fairness and completeness of the process behind us. And as I've said repeatedly, as soon as we are able to do so, and as soon as this is before the courts, we will gladly release the report in full and in complete so that anyone can view it. But until that it is before a competent court, as it is a key piece of evidence, it would be extremely reckless to jeopardize that evidence and see those that are accused of wrongdoing let off the hook. Honorable Peter, I must say that I'm not entirely clear, but I think that the question that you're asking is around how long has the IDT board been there. They were appointed in July, if my memory serves correct. They're a new board. You'll recall that the previous board had become incorrect, and we went through a process to appoint an interim board or a supplementary colleagues to the IDT, and then Cabinet approved a new board that was then instituted, I think, in July. And that new board is now trying to steady the ship and resuscitate the IDT and make sure that it's able to do its job of delivering social infrastructure. I think some of the changes that we've brought, certainly under the 7th administration, is dealing with the IDT and making sure that it is competent and fit to do its work, and where there are problems and allegations, to deal with them speedily and robustly. And I think that the department is achieving a great deal in the 7th administration, not just with regards to the IDT, but some of the new and innovative plans that we've put forward, like the South African Action Construction Plan, some of the work that we've been doing around reform of public employment through the new IMC that was launched last week, through some of the work that we're doing on some of our asset utilization. So I think that there's numerous instances of where we are achieving good work. Of course, there's a lot to do and a lot more that we can do. And I assure you, Honorable Peter, that we work every day to make sure that we realize the goals of what we've set for this this term, and to make sure that we achieve them. Mr. Mhlanga, I don't know if there's anything you would like to add or the board would like to add.
No, thank you, Minister. No, I think you've covered. But suffice to say, just in clarity, I think basically the issue of the roles and responsibilities, I think you've exhausted the aspect of as an executive authority with regards to this investigation is the clarity of in terms of roles and responsibility. And I think honorable members will see that even the structure of the presentation was saying the reason why we started with the allegations and the responsibility of the minister in commissioning it was purely on what we call the primary investigation or preliminary investigation in relation to the allegations. Then second to that, now that the preliminary is concluded, then the actions, which is basically the actioning, the consequence management or any form of action that is taken on the basis of the findings of the preliminary is now the responsibility of the board. And you will see that in that post, that is the board. And then the third aspect is that any criminal aspect of it will be dealt with by law enforcement. Hence, the minister also referred the matters to the Hawks law enforcement. So that is also to enable, that is also to clarify the roles and responsibilities of the minister. In this case, it was purely in looking at the reputational and of the IDT as his executive authority, but also to look at ensuring that in future the entity has manages the procurement processes as well as the reputation of the entity and sustainability of the entity as far as doing that preliminary. That's the first part. The second, I think there were issues around the training. What was is the investigation suggesting that those concerns, those that are concerned or officials concerned, there's a gap. No, I think what the investigation is saying basically as part of a systemic recommendations when one of the issues being training is that it starts with the composition of the committees. For instance, if you look at the BSc, the specifications, that is normally the core team that basically understands the project. And the evaluation, you'll see that it's also the core team and others that will be responsible in executing that project. But there's the core team, you may find that they may not be au fait with some of the procurement or SCM related matters. And so the training is basically to say, whenever there is a composition or whenever there's an appointment of these committees, they must also be taken through the SCM process to have an understanding of what are these issues. For instance, one of the issues we're raising or raised by the investigation report here is that the threshold, according to CIDP, of this one company was 200, but the allocation was above 200. Now, that ought to have been clearly understood by the committees that were involved, that was going to be a guiding principle in terms of. So those are the kind of type of trainings that we're talking about in ensuring it, but not necessarily to say that there's a gap, but it's just continuous training because there are changes in procurement legislation, changes in prescripts, changes in delegations, and therefore the organization as a whole ought to be au fait with those changes as they administer contract administration or contract management as a whole. Thanks.
Thank you very much, Mr. Naidu. Is there anything from the board side that you would like to add at this stage, or shall we continue?
Honorable Chair, no, thank you very much, and members. Just to respond to the supply chain issues, I do want to confirm, I think that in terms of the report is replete with gaps with regard to supply chain matters. I think that the presentation patently indicates that there's been a contradiction between the MOU and that which went out into the RFP. I think that's a fundamental flaw with regard to this particular tender, and it goes on insofar as the composition of the committees, the manner in which the committees then adjudicated on this particular matter. So I think that the report has been put before us. But in terms of what we're doing now, I think that if I could just indicate that we have evaluated our supply chain processes, we've looked at our policies, and clearly I think that there are serious issues with regard to how supply chain is being conducted within the IDT. I think that finds itself expression in the latest audit report, and we have now asked our executive authority for assistance with regard to restructuring the entire bid processes, and also to look at whether we can professionalize our bid committees. The IDT, I think, as you know, is very challenged with regard to resources and the budget necessary to fill in posts that we have there. So the matter is being attended to. Ms. Nene could augment what I'm saying with regard to looking at training that is being done currently for the bid committees. Thank you very much.
Thank you, Mr. Naidu. Honorable Peter, I see your hand is still up. Can you just remove that hand? We will give you another opportunity when we go around for follow-ups. But just for now...
But my question is not answered, sir. If you can assist me. If you hear my question has been answered, it's fine. But I didn't hear my question being answered.
Okay, so can you just articulate your question one more time? Because I must just add that you are not very audible. Your sound is not great. So maybe just, they didn't hear your question. So maybe just, can you just articulate your question again?
My question was, ministers who comes and go, doesn't prohibit the department's achievement? That was the first question. The second question, what prohibits the departments not to achieve what they're supposed to achieve? Those questions I didn't hear been answered, Chair. Thank you so much.
Thank you, Honorable Peter. Honorable Minister, do you want to just address that question, please?
Thanks, Chair. I mean, I think that, there's many factors why departments won't achieve things, and whether it's through unqualified staff, budgets, lack of regulatory guidance. So there's many things that might affect a department from not achieving. It may have a bad annual report. I think that we could have a long list of that. But I'm happy to say that I think that when one looks, slowly but surely, we are getting those things right. Obviously not the budget point. That's not within our remit, unfortunately. But some of the big things that require decisions and require, policy positions, are being done. So I hope that gives maybe a little bit more clarity to Honourable Peters. Thanks.
Thank you, Honourable Minister. Honourable Molokome, would you like to pose your questions, please?
Thank you very much, Chairperson, and greetings again to Minister and the officials and members of the board. Chair, my questions, I think I have about 4 or 5 questions, but I'm going to be quick on this, straightforward. How long is the investigation going to take? That's my first question. What are the internal control that you have identified as weaknesses in the supply chain management, and how are you intending to strengthen internal controls to prevent the occurrences in future? Because I don't think we will want to see the very same problem or issues happening in future when coming to the issue of the supply chain. So how are you intending to strengthen and make sure that the very same thing is not going to happen? How often do you review your procurement policies? The fourth question that I have, Chair, do you believe that, or do you think that colliding can be the center of all this maladministration, or do you think it's a failure of the system in place to prevent officials from doing this manipulation in the department? The other question, Chair, is in terms of the accounting office. That accounting officer has signed, because I heard that the CFO is been suspended. So I just want to know if the accounting officer that has signed the documents or the appointment letter, what has happened about the accounting officer? Because in my take is that he signs the final documents. So what happened if about him if the CFO has been suspended? Because I believe that is his responsibility, final responsibility to sign those documents. So I just want to know what was the action taken against him, because, or was the CFO acting in his behalf when this company was appointed or not? So those are the questions, Chair, that I want to ask. Thank you very much.
Thank you, Honorable Molokome. Can you just repeat the question before the question you posed now? I didn't get that question clearly. I think it's about collusion of staff members. It's the one, I think that's your fourth question that you asked.
I was asking if do they think that there's a collusion of officials?
Okay, thank you very much. Got that.
Do you think collusion is the center of all this maladministration? That is the question that I'm posing.
Thank you very much. Honorable Moimang, over to you for your questions, please.
Thank you, Chairperson. Let me again also express an appreciation from the briefing that we received from the Honorable Minister and the board and the DG. Just three from my side. The first one relates to out of the expected PSA or pressure swing absorption oxygen plants, the one that was supposed to be provided to 60 hospitals across the country. How many were delivered? The second one relates to whether is there a case to suggest from the investigation that there was a consortium that involved Balking and Atlas, the one that provided them with the SHRAF certificate, and whether in terms of the investigation is there value for money, because that is not coming through from the presentation that is made, because I'm looking at the scope as articulated by the DG and the finding it doesn't indicate as to whether the Department of Health had an issue in terms of the performance, because obviously the IDT, the instructing department, or the client in this case was the Department of Health, and whether the Department of Health on its own have also instituted investigations, because I find it there's a point where there is a referral to the request by the Department of Health to broaden the scope of the investigation. Well, is there an update as to whether the Department of Health expect the PwC to continue with that, or the Department of Health will appoint its own service provider, or there is an agreement between the Department of Public Works and Health for that to happen. But of course, given the line and line of accountability, it's a bit confusing, because my understanding is that the Department of Health, if there is a case to suggest that they are officials, there was a collusion between the department's officials and IDT, then they must be able to do that on its own, not necessarily to request the investigation to be broadened into related health officials. Thank you, Chair.
Thank you very much, Honourable Moyemang. Let's take those questions, Honourable Minister, please.
Thanks, Chairperson. Thank you for the questions. I will refer some of them. I can't tell you, Honourable Member, how long the investigation will take. I think that is best referred to the SAPs. We don't interfere in their investigations or pressurize them. In terms of the HR investigations process, I will allow the IDT board to deal with that. In terms of the internal controls identified, I'm sure that GRC and IDT will deal with that. In terms of reviewment, or so at least the review of procurement policies, I do not get involved in procurement. So I will also allow GRC to do that. Suffice to say that we obviously have a new head of SCM who will be starting. Was there collusion? I think that there is no doubt that the report paints a picture that there was at least some form of collusion between officials. I think that there are too many pieces that had to fall into place for this to take place. I think that there was also a severe lack of oversight from the board, the previous board, particularly when this issue was raised in the public domain. Their response was a no response, and that there was nothing to see and that there was no problem. And when I repeatedly asked them for the details surrounding this issue, they stalled and delayed and gave me half pieces of information. And then at one point they said that they believed that there was nothing wrong with the entire process, and then admitted at the end of December last year that indeed there was a problem. So I think that there were just too many things that took place for one person to act on their own, particularly with how the company bulking operated, how it accessed a license, or how it basically fraudulently used someone's license, how that was never verified, how they awarded with a tender that they didn't qualify for, how a company that didn't even have an address or any sort of references were awarded that sort of business. I think, points to a picture that this was not one person acting on their own, but that obviously has to come out in the subsequent investigation. Honorable Moimang, as I recall, no oxygen plants have been delivered, and that the process is now being done through the DBSA as the implementing agent by the Department of Health. Although I do understand that one part of the contract is still with the IDT, but the IDT can respond to that. I think I've responded to the point around whether there was, some sort of focus between bulking and how they got a certificate. Whether there was value for money, Honourable Member, I'm not an expert to be able to determine that. I think the point that the contract went up so significantly from its original 260 million rand to its proposed 800 million rand would suggest and propose that there's something seriously wrong with how those final prices were adjudicated. I can't talk to what the Department of Health does or doesn't do, or how they hold their officials responsible. We of course have done, a lot of work, Honourable Moimang, on this matter, and as it relates between the IDT and health, it makes sense that because there is institutional work that's been done by PwC, that they then expand that onto the health side, and that was a request that came from the minister. But anything further than that related to the health department, I think would be best placed towards them. So let me ask GRC to answer any questions, and then the IDT to answer those questions that I had allocated to them. Thank you, Chair.
Thank you, Minister, and also thank you for the questions. The question that was raised around if we any issues or internal control weaknesses, yes, I think again linking that to the allegations that were made in the media, and I think what the investigation report is pointing to, one, is that there were procurement irregularities. And the procurement irregularities we also highlighted from the memorandum of agreement, the IPIP, that also, and how then the structure of the request for quotation was structured, which then omitted the SAPRA as a requirement for the bidders to actually appoint, to supply that information as part of the RFQ linked to the memorandum of agreement. And then three, were also the issue of the provision of, especially in the case of Balkan, the provision of the SAPRA SAPRA certificate or license after the close of the date, the procurement date. That is also points to irregularities with regards to that. There's also issues around risk management, and risk management basically is the failure to effectively manage the risk, particularly from a procurement point of view, is one. There was the CIDP threshold of 200 for specifically for this company Balkan, but it was offered or allocated some more sites, 45 sites, and with an amount of over 400, which means that the allocation of that disproportionate allocation over its threshold at CIDP grading, that also is a irregularity, which means that there's an oversight from the committees in terms of that. Two is also the issue of disclosure of information, particularly practice note, National Treasury, which basically talks to subcontracting, where the subcontracting of this, anything up to 25%, you need to disclose that information. Now, with the Balkan and the allocation of more than 170%, more than that 174%, it basically meant that what then was the role of the principal company or the primary company vis-a-vis the subcontracting, but that information was not disclosed as per the procurement regulations. That also points to violation of the regulation as well. Then there are also issues of record keeping, because part of the issues of procurement contract administration is proper record keeping. And I think the minister also alluded to the fact that it was a toing and froing to actually get the information from these processes. It took quite a long time to get this. So there is some degree of limitation with regards to information. And that also points to poor record keeping from a procurement point of view. And then largely the issues of compliance and regulatory issues. Compliance with SAPRA, the licensing issues. So it was an oversight on the part of the committee from an SCM point of view. That is also an irregularity and also a weakness in the control. And also compliance to prescripts section 217 of the Constitution, as well as the National Treasury regulations on preventing and combating fraud and the conduct of members of the committees. So those were the issues that that the investigation points out as part of or as internal control weaknesses within the supply chain processes. Then the procurement process, how it's done, particularly from an investigation point of view, is that there is a panel of investigators that the department manages, that as and when there's a request or for investigation, we then subject that to a procurement process of the panels on the basis of them. Also, they will also follow the same process of request for quotation with respect to the scope of that specific investigation, and then we internally process that. But that is one of the issues that I raised earlier on the risk management, is whether there is also to test the ability of the bidders to be able to perform as well as align to the scope, and that also is a process that we follow. You do find cases where you find that the issue is not necessarily about the price, but it's more about the ability and the capability and the integrity of the service provider in line with the scope to be able to discharge that function and meet the requirements of the department. So we also have that vigorous, and that process is also supported by the internal processes of the accounting officer deviating from the norm which is allowed within the prescripts of that. So those are the processes that we follow as well internally in the department to do. But from investigations, especially of this nature, we go through a panel of investigators that are part of the database of the department in dealing with these panels. Dealing with the investigations. Thank you. Thank you, Chair.
Thank you, Mr. Mhlangu. Mr. Ntalini, can you just check? I noticed in the chat that it looks like Mr. Nzibande, the acting CEO, was it somebody has been kicked off the platform and is trying to get back in the waiting room? Maybe just assist if you can there.
Yes, Chair, will assist for him to rejoin as the acting CEO. So it's out of the system for now.
Okay, great. Thank you very much. Just so that somebody notes that. Thank you. Let's go over to Honorable Skierkogel.
Good morning, Chairperson. Let me just do this, make sure that everything is fine. All right, good morning, Chairperson. I think you have alluded that some of the questions might not be able to be answered because it's still waiting. So I just want to find out, I think that it was mentioned in the report that the initial cost that ballooned from was 260 million to 860 million. I just want to know what were the factors, why, what led for that, and how did they justify it at that moment. Then also in the PricewaterhouseCoopers report, it recommended the disciplinary action against the CEO and highlighted about 400 employees that was earmarked for lifestyle audits. Now, beyond the CEO's suspension, what progress has been made on these disciplinary cases and audits? And what are there any other further officials that have been suspended or charged? And then maybe maybe we won't be able to answer this, but or maybe it came from the PricewaterhouseCoopers report. Why the internal warnings to restart the tender process was ignored. So the report shows that the IDT Internal Steering Committee recommended that they restart this procurement due to that cost escalation. I think that's probably linked to my first question and the specifics problems. But the CEO and the health DG, they proceeded with this. So I just like, who authorized this the ignoring of these warnings, and what accountability measures are planned for those that did override this procurement process? And then I think that's it, because I think most of it has been answered, and I think some of the questions that I did have prepared, Chairperson, won't be able to be answered today until we get the report from PricewaterhouseCoopers. So those are just, in short, that not usually I'm short, questions that I have for them today. Thank you, Chairperson.
Good. Thank you very much. We appreciate your time management this morning, Honourable Skeerkogel. Honourable Makasini, would you like to have a stab?
Thank you, Chair. Greetings, members. Chair, my question is just a follow-up on the question of Honorable Mulukume regarding the other officials that were implicated in the report. Although the report is not yet ready to be maybe presented to the committee, what measures are they doing to make sure they do protect, or is there any plans or a system that maybe they have removed them to the supply chain and giving them other responsibility, or are they still there because they are still waiting for the process of investigation? Lastly, Chair, what time frame can they give us maybe to present the actual report to the committee? So that you can get a detailed report, because whatever that they're telling us is the scope that they have determined, but the report is with them, but they are not ready to share with us. When are they able to share a report with us?
Good. Thank you very much, Honourable Makasini. I think that one question that comes through from more than one member is the status of the disciplinary processes, and maybe the IDT board can address that question. Let us go over to the Minister, though. Thank you very much.
Thank you, members, for the questions. Honourable Skeerkogel, let me just say the cost increase. Let me leave that, because I think that is to be determined, except to say that I think that this is the problem with procurement, is that it's, these things just go through various cost estimates, and then the scope keeps changing, and the costs keep changing, and this is just something we've seen over and over, and that's why it's very difficult for us to determine whether there is, value for money, because the scope of the project continuously kept changing. But the IDT maybe want to respond to that. The issue of 400 employees under lifestyle audits, that relates to the department, not to the IDT. I will allow the officials or the IDT to say if there are any other officials that have been mentioned in the report that have been charged. Also, with regards to the internal advice to restart the process, I will allow the board to answer that should they deem fit. Honourable Makasini, I will also allow your question on whether officials implicated have been removed or put somewhere else to the board. And then just to highlight again, when we can present the report will be that once the charges have been brought by the NPA and it's before the court, we'd be able to do so, because obviously this report forms a key part of evidence, and they don't want evidence to be placed in the public domain until those charges have been formulated and it's before the court. So we really are within the police and NPA's ambit, and I think that we must respect their advice and request to us, which we do. Of course, our primary objective is to secure convictions. I really want to say that I think that South Africans are tired of seeing people walk off or people not being held accountable. And we really want to honor our commitment to make sure that people are held accountable and do face the music. And so we need to do everything within our power to ensure that that takes place. I don't think, Lawazi, there's anything for you, so I'll hand over to Derek then. Thanks.
Chair, thank you. Thank you very much, Chairperson and Honourable Minister and members. I think if I could just address myself to the questions raised by Honourable Member earlier that dealt with the issue of, and I thought it was a very good question because I think it deals with the issue of controls, internal controls. I could just provide assurances that we have, as a board, started dealing with this matter. We had a thoroughgoing of our delegation of authority because that's where everything starts. And we've now revised the delegation of authority. We've looked at other entities across the board, and we have drawn experiences from them, and we've revised our delegation of authority. That delegation of authority gives us more oversight because in the current or the delegation of authority previous to us adopting by the board did not allow for oversight on supply chain matters. And I think that we saw that as being very problematic. And if it did, then those were merely reports that would come to a committee. We've now strengthened the delegation of authority where supply chain now has to report to the board and has to report to the Audit and Risk Committee. So those are the immediate internal controls that we put into place in dealing with the arising out of the report that we've received. With regard to the review of policies, again, I think that's done on an ongoing basis. Policies are either reviewed annually or when and if it is necessary, given the change in legislation. So legal department would bring that to our notice, or the department dealing with the supply chain would bring that to our notice, and we would then review accordingly. We've had lots of discussion with regard to the changes in the procurement policies and regulations. I think, as you know, that significant changes have gone through with regard to that, and we've taken note of those changes. But having said that, we are overhauling our supply chain processes and the supply chain policy to bring it in line with best practice. With regard to the consequence management, I think as we've indicated and as the report has indicated, we have begun the process. I think as correctly stated that the CEO was suspended based on the report that was favored to the board, and the matter is being processed currently. Charges have been preferred against the CEO. Chairperson has been, external chairperson and initiator has been appointed to deal with that particular matter. So that matter is being processed, and we're hoping that it would be concluded sooner rather than later. With regard to the other officials that have been responsible for the signing of the appointment letter and so forth and so on, those officials are also being dealt with. Charges have been preferred against those officials and indicating why they should not be suspended. We have received responses from those various officials, and that matter is now being considered. We will start the process of disciplinary inquiries against, but we haven't suspended any other official, given our need to follow proper HR processes. So yes, so we are proceeding with those matters. Yeah, I think that those are the matters that was raised there. None of the officials have been removed from the supply chain processes. Um, as yet, I think, given our investigations, and once our processes are online, we then start dealing with the issue of whether we need to remove or not. We are very thin on the ground, so I think that puts us in a very compromised position. We have a book of 5.2 billion that we still got to deal with, and or we've dealt with about 2.6 billion now for the first 2 quarters, and obviously supply chain processes need to proceed in order for us to meet our targets as the IDT. Chairperson, I think I have addressed. If my colleagues want to augment, then they are free to do so. Thank you so much.
Anything additional from the department?
Check.
Good. Let us then. Yes.
Chair, my name is Sumtibanda. I'm the acting CEO of IDT. I just want to comment on the submission by my trustee, Derek Naidu. We just on the issue of disciplinary, Chair.
Mr. Sibanda, your phone is very soft. The sound is very soft. So I don't know if you can maybe try and make yourself a little bit more audible.
Can you hear me now, Chair?
It's a little bit better. Thank you very much. And you're welcome. Thank you. Please continue.
Chair, to update, I think this week, Chair, we have issued a suspension of the GM's supply chain. We were still going to process that suspension to the board. I think our member has not been updated on that aspect, but just on the issue of the oxygen, PSA oxygen, we've suspended GM's SCM, who was part of the people mentioned in the report. So yes, Chair, I think just add that part, Chair. Thank you.
Thank you for that. Honorable Moyemang, I see your hand is up. If it's a follow-up question, can we hold back on that, or is it something clarity on something that you already asked?
It's a follow-up, Chair.
Okay, great. So we'll do follow-ups just now. I just wanted to, I don't see any further hands, honorable members. Honorable Mabebu, did you have any questions? I don't see your hand.
Yes, Chairperson. Let me start by greeting your good self, Honorable Chairperson, and greeting to the Honorable Minister. And then my question is, has the department made sure that there is monitoring as far as supply chain is concerned, and ensured that this doesn't happen again? But over and above, I'm covered with everything, with the explanation that the department and the ministers have done. Thank you very much, sir.
Thank you very much. Honorable Minister, just from my side, and this is just maybe a more practical explanation of how things work. So excuse me if it's not a general question, but I've picked up in the presentation that there was no authorization for Bulking to use the SAPRA license of Atlas Copco. So I was just wondering, was Atlas Copco also one of the service providers that tendered? And is it common practice then for companies to use each other's, in this case, for example, in this tender, to use each other's SAPRA accreditation to qualify to do the work? Because that to me seems fairly irregular. I mean, if company A doesn't have SAPRA accreditation, they could then go to company B and say, can we use your accreditation so we can then get the work and the tender? That's the one question. And then just has previous performance been taken into account for companies? I've got a very specific reason for asking it, because in the NCOP we are clustered. So a lot of our members serve on different committees. So I happen to serve on the Joint Standing Committee for Parliamentary Finances, or with the Financial Management of Parliament. And with the demolition of Parliament, a company's name came up, Mazia, General Services, and they were involved in the demolition of Parliament. In my committee work with the Department of Transport, the same company came up with the tender with regards to signaling that has gone awry, and there's question marks over that. There's a 17 billion rand tender, and there's question marks over that company and that tender. There were some question marks over the demolition of Parliament as well, the old burnt part of Parliament. And now I've noticed their name coming up again with the oxygen tender as well. So my question would then be, does the CIDB grading threshold, is that applicable to work done by a supplier across departments, or is that CIDB grading only applicable to a company that does work through public works? That will be the one question. And then obviously our first question was, is previous performance taken into account when tenders are awarded, and if not, will it be done in the future? Because I think it's quite important that, that if one company's name keeps on popping up and there's question marks in that company's performance, we've seen this department act previously with underperforming companies. If that is going to be a factor that's going to play a role in the education of tenders. Thank you very much.
Thank you very much, honourable members. Let me start with Honourable Mabebo. I will ask the department to deal with the issue of monitoring in terms of supply chain. The question of, will this happen again? I would hope not. But for as long as we don't take harsh action against individuals and see those held accountable for this kind of wrongdoing, it will happen again. And that's why, Honourable Member, I'm so determined to make sure that we secure some form of conviction one way or another against those implicated. Because if we don't, and they walk off scot-free, then it will just incentivize that sort of behavior. And that's why, again, I state it's so critical that we respect the process that is underway to ensure that we reduce the chances of this ever happening again. If we want to increase the chances of this ever happening again, then we should let those people walk off, and then it'll happen again. So I think I would be dishonest if I came here and said, well, this will never happen again, because unfortunately humans are, subject to their own desires and temptations. But we can obviously do everything that we can to reduce that. And I think that technology can also play a big role in taking away the human hand of awarding tenders, and that we award tenders on fitness, on performance, on cost, and so on. Honourable Chairperson, let me say that no person may use another person's SAPRA license to bid for a job. You have to have your own SAPRA license. The issue here is that bulking used Atlas's license, and Atlas didn't even know about it. Now, that should have been a red flag right away, and yet it wasn't. They still proceeded on that basis. I can't recall, I stand to be corrected, whether they were a bidder or not. I'm not entirely sure. But it was patently obvious that bulking did not have their own license. And so they should have been disqualified on that basis. CIDB grading is applicable to a company, and that is used across the board. So any company that is graded 9 or 8 or 7, it's not graded department to department. It's a flat grade, if I can put it that way. When awards are taken or undertaken, of course, and there's a number of things that are looked at. Price, performance, all that sort of thing is very important. And that's why if there are allegations of underperformance, those must definitely be reported so that they can be investigated. I am not aware of any current investigations into the company that you mentioned for underperformance. But if there is substantiated allegations, those should then, of course, be made to the department and to the CIDB to be investigated. I don't, Lwazi, would you like to answer on monitoring of supply chain? Thank you.
Yes, thank you, Minister. Thank you. I think the question around is, I think we play a role in terms of the interest of our entities, because the part of the role of the entities as the implementing agents of the department is that we also have continuous engagements as well as monitoring of the supply chain. Though they have they are as a legal entity have to do their own, but our interest is more in ensuring that the work of the entities also does not put the mother body in disrepute. So there are those quarterly performance assessment reviews, which are led by the minister, part of which will include the service delivery, but also financial expenditures, as we also provide transfers and subsidies to the entities, but more so an interest in terms of how those monies are being used, as well as the procurement processes followed in ensuring that service delivery is adhered to. So those are some of the quarterly assessments that we do, but also ensuring that there is also continuous monitoring of those procurement processes, but not having direct influence and also direct visibility. We as a department, because entities are illegal and they are also a legal entity, we don't participate in that, but we do have an interest from an oversight point of view to ensure that those procurement processes are followed as a mother body as well. Thanks.
Thank you very much. Honourable members, there is time left for follow-up questions, just by show of hands. I see the hand of Honourable Nzimande.
It was mine first, Chair, don't forget.
Oh, sorry, Honourable Moyemang. You can go first and then Honourable Nzimande. Thank you very much.
Thank you, Chair. Chair, just to one for myself, because it looks like there are two events that triggered this investigation. The first one relates to the audit findings. The audit findings of 2022-2023 of the IDT, where the IDT reported that it had initiated an investigation into the allegation. Then the second trigger is the print media report of in 2024, where alleged irregularities were identified. But it will be important to get a sense, given the fact that the first time when this was picked up was during the auditing of the financial year 2022-2023, whether the department could just indicate to us as to whether this investigation by the IDT, were they not happy with it, because there's a sense that also there was a session, the IDT board then decided to cede this investigation to the Department of Public Works. Whether the department, in terms of its work, whether it is the internal audit unit or the audit committee, were they not happy with the outcome of what the findings brought to the fore. Thank you.
Thank you, Honourable Nzimande. Would you like to pose your follow-up questions?
No, thank you, Chair. Like I said earlier, it will sound a bit flimsy from the department to argue that they can't disclose the full detail in relation to the companies that were involved or service providers and only release two, because there will be number of companies that we should also be given clarity whether they were properly treated in the process. So they have cooked or have baked accounting to Parliament. It may not be correct. The second part that we have raised, I guess also the department is deliberately evading the question. The question is clear, is that there can't be two right questions here. It's either one is correct. It's either PricewaterhouseCoopers findings in relation to identifying those that were involved is accurate, or it was not accurate. It's labor relations that has now detected what is accurate. We are asking the minister, knowing very well the board account to him. He's the overseer. He's the one to account here. All what we are asking is very clear, is that an implied admission that the findings of PricewaterhouseCoopers are not accurate if it is accepted that the representation that were made that have cleared that appeal by the labor relations is the one that must now be taken through and is correct. And the last one that also in terms of the follow-up I've raised is that they can't be correct as a department to say the training that is initiated as per the finding has anything to do with their response to say it's an ongoing training because there are changes in policies and they must adapt. That will have been separated. The question I was raising, is this an admission to try and say there were gaps in terms of the competencies and abilities of individuals? And that will be the mitigation that any trade union will use to say these workers did not commit any intent to commit fraud. They had no intent to commit fraud. Why this is put in this report? Thank you.
Thank you very much for those two questions. I don't see any other hands at this stage. Honourable Minister, would you like to answer those questions, please?
Chair, I just missed the first question. Sorry about that. It's the first follow-up.
Honourable Moimang, could you just please, sorry, I also lost connectivity there for a second. Can you just please give us your first question again?
Thank you, Chair. My question related to the fact that during the consideration of the 2022-2023.
Oh, yes. Okay. Thank you, Honourable Member. I recall now. Honourable Member, I think that maybe actually relates to the lease that was then transferred to the department to be investigated. So I will allow the GRC head to respond to that. Let me just say to the Honourable Nzimande, it's because we want to avoid half-baked accountability that we must do things properly and that we must do it correctly, and we must follow the advice of the SAPS, the NPA, and our legal teams. I'm not prepared to see people get let off of the hook and be re-employed by the state or somewhere else and wreak havoc there for expediency. That is not what we are about. We want full accountability, we want full answers, and we want the full process of the law to unfold. And that for us is just simply non-negotiable and something that we must all surely collectively agree on and demand, because the public of South Africa are quite frankly tired of seeing people accused of serious things, whether they are through reports or on camera, of doing egregious activities and then being let off the hook because the state bungled the process. We've seen far too many instances of that taking place, and I'm certainly not willing to see that take place under my watch. With regards to the PwC and labor relations, well, I mean, I think, Honourable Member, one flows from the other. That the labor relations processes of the IDT flow from the PwC report and have to be tested through a labor relations process. I hope that we never get to the point in a country as South Africa, which is a constitutional democracy, that says that you can simply lose your job on the basis of an investigation. Every investigation has to be tested through a labor relations process. Every allegation has to be tested in a court. There's always a process that follows an investigation. Those are the laws of our countries. I respect them. And if people are found innocent off of that, then so be it. But it doesn't negate or take away from the veracity or from the investigation in the report. So one follows from the other. We must always test those, and then we see what the consequences are of those. And of course, the state always has the opportunity, or anyone always has the opportunity to appeal the outcomes of any process. So I think that we must allow every process to unfold. We assess the outcomes from there, and then we decide on the way forward. But I'm very confident in the veracity of the processes that have been taken place. We are guided by expert advice. The board is made up of competent people who are also subject experts in HR and legal processes. And I think that I will allow those processes to unfold as need be. Thank you.
Thank you very much, Honourable Minister. Honourable members, I don't see any other hands for follow-up questions. So if there are none, that only leaves me to say, Honourable Minister, thank you very much to yourself and your team and the board members this morning.
Chair, the Minister deferred one question to...
Oh, sorry, I missed that. Yes, I think I now recall there was a question that the Minister referred to the department.
Thank you, Chair, and thank you. I think there were two issues. If I'll be guided on the first one, let me just respond to I think there was a question around training. Maybe just to contextualize the reference to training in relation to the investigation, is that part of the investigation, owing to the evidence that would have been uncovered, is to make systemic recommendations. And systemic recommendations is not necessarily to say that there are specific or rather, systemic recommendations is basically to inform policy, to inform practice, as well as decision making. And when when the investigation was saying provide adequate training to members that are involved in SCM processes, including all the BSc, BScs, and BAC The issue was basically saying training in relation to procedures that should be followed as part of the evaluation of the bids. And that is also borne by backed by the National Treasury Instruction Note on prevention and combating abuse in the STM process that says every member of the bid committee is jointly and severally liable for the improper evaluation and adjudication of the bid. And we're saying, owing to the changes in the procurement space, whether it's an instruction note of Treasury, whether it's a code of conduct, code of ethics, business continuity processes, delegations, some members or the composition of bid committees, they may not be fair with these changes as they form part of the the committees. And we're saying that continuous training or being made aware of the changes within the SCM is critical as part of the system to avoid these issues to avoid irregularities. And I made mention of the one example which Minister also alluded to. A grade E ME, which is mechanical engineering from the CIDB, has a threshold of 200. And it must also provide, I think, between 30 to 90 million over a period of financial years. And the company that was awarded, or in this case, Balking, was a grade 8 ME, and our location was more than the threshold of CIDB. Then we're saying, as a result of that, there ought to have been also for the future members that will participate in the procurement space to be trained and made aware and understand those nuances when it comes to this, to prevent irregular appointments and irregular awards. And that's basically what the training in terms of systemic training is talking about. And it's not an admission that those were incompetent, but it's just a systemic recommendation to prevent future or irregularities in future. If I may be assisted with the other question, Chair.
Was there another question from your side, Honorable Moimang?
Yes, Chair. The question was, given the fact that the first time when this issue was raised was during the 2022-2023 audit findings, and the IDT then started with the investigation following that audit finding, which it is reported that then it was ceded to the Department of Public Works. The question that I wanted to check is in relation to the strength and the reliance on the oversight bodies on the part of the department, whether in terms of the work that the internal audit unit of the department was doing, or the internal audit unit of the IDT was doing, were they not happy with the progress that was being made, because it was first raised during the 2022-23 audit finding, but the second one was then, it was in the print media in 2024, which I suspect could have triggered the attention. Thank you.
Chairperson, if I may.
Please continue.
The issue in 2022-2023 relates to the lease of a new building that the IDT were doing. They're two separate matters. So that was then referred to the department's internal audit. And I think then there were some investigations done. It was then handed to National Treasury, but GRC can tell us where that is. The issue of the 2024 matter is totally unrelated. It's on a different matter. That then relates to the oxygen plant tender. Because it was so complex and complicated, I felt that it was best placed to be given to a forensic auditor, and also knowing that we needed to deal with it expeditiously as well. I will say, Honourable Maimong, that it does So our internal audit unit is severely undercapacitated. We need to have more people, forensic auditors, forensic investigators in our internal audit. It is something that I've tasked the department to do, that we are able to deal with. I mean, not all matters will be able to be done by the department. There are some matters that are very complex and very technical and require outside expertise. But there should be more capacity within internal audit to be able to investigate. But just to say that the issues are separated, maybe the GRC can just tell us where that process is, or where the response is on the lease investigation that was eventually then with Treasury. Thanks.
Thank you, Minister. Thank you also for the question. Yes, following the recommendation that was made by the internal audit, that is the internal audit of the department, they did their own assessment, and then they recommended a forensic investigation, which then came to the GRC, Governance, Risk and Compliance. That was conducted, and the report was concluded and presented to the accounting officer for further assessment. Now, parallel to that, if members would recall that at that time, there was also the transition in terms of the board members who also had instituted their own, and then National Treasury was also they also instituted a investigation. And members will also recall that I think also the National Treasury investigation, when it was concluded, the then board had concerns over that investigation, and then I'm not sure what then happened in terms of the board then. But suffice to say is that with the current board, I think they've instituted, resuscitated that process through an external party to also look into that lease investigation. Internally, the department, that was concluded, which will form part of or the base for the further investigation that has been instituted by the current board of IDT. Thanks.
Thank you very much for that, Mr. Mashlangu. Honourable members, I don't see any further hands. Honourable Minister, would you like to make any closing remarks? Honourable Minister, I'm not
Thank
sure
you.
Yeah,
Thank you. Thank you very much. Thank you very much, Chairperson. Thank you to you and the committee for the opportunity to present to you today. Always a pleasure. We're grateful for the support and advice that we get from the committee as well. And we look forward to coming back with the next iteration, hopefully sooner rather than later, to present in its entirety. Thank you very much to the officials and to the members of the board from the IDT. And certainly from our side, we wish you well, Chairperson. Thank you so much.
Thank you, Honourable Minister. Let me appreciate yourself and the IDT board and your department for attending and briefing our committee today. I think you've done a lot of work in ensuring that you have a functioning IDT board, and in doing so, acknowledging what an important role the IDP could potentially play with regards to developing vital infrastructure in our community. So thank you very much for the continued work that your department is doing, and that the new IDT board is also doing, and we must acknowledge their work as well. And from our side, our committee will accept your offer to peruse the full forensic report once it's available, and we shall certainly invite you back to do some more oversight. Thank you very much for your attendance. You and the department are now, and the board members are now excused. I just wanted to do some homework with the rest of the committee with regards to previous minutes. Honourable Minister, thank you very much. Honourable members of the committee, Mr. Mthaleni, we have two sets of draft minutes that we have to go through for approval. The first set is the draft minutes of our meeting on the 28th of October. That was the briefing by the Department of PME on a provincial breakdown of the nature of allegations reported via the presidential hotline. and then also the Parliament Legal Services briefing us on the Economic Regulation of Transport Amendment Bill. There was a very small amendment that's now at the moment out for public participation with regards to the date on that bill. Let's go over to attendance. These minutes have been sent to you for perusal, so I assume all the members have had the time to go through them. Following page, please. Thank you very much. Opening, apologies. Thank you, H. You can continue. Proceedings. The committee deliberations. Briefing by the department on that bill. Thank you, H. Continue. And the minutes of the previous meeting that was adopted. Thank you very much, honourable members. Can I have a proposal for these minutes? Or if there are there any comments or questions or alterations? I don't see any hands. A proposal for the minutes, please.
Chair.
Thank you very much, Honourable Molokome. A seconder, please.
Chair is Peter.
Thank you, Honourable Peter. Much appreciated. H, can we do the next set of minutes as well, please? Thank you, honourable members. These minutes stood over from the last meeting because we were not quorate, so we had to let them stand over for this meeting. That's the minutes of the 5th of November, and that was the briefing by the Department of Public Works and Infrastructure on their 2024-25 annual report. That's the attendance. Once again, these minutes have been sent to you prior to this meeting for perusal, so we'll just go through them very quickly. Opening, apologies, proceedings, deliberations on the committee side. And the adoption of the minutes. Thank you very much. Honourable members, can I have, again, a proposal for these minutes, please?
I move, Chair.
Thank you very much, Honourable Moimang. Can we have a seconder for that, please?
Peter seconded, Chair.
Honourable Peter was present in that meeting. Let's just confirm that. We're going to need somebody who was present in the meeting to second the proposal by Honourable Moimang. So that would be ideally Honourable Nzimande or Honourable Mabebu. If either of you could second that, will be much appreciated.
The Chair can second. Fine.
If there's no problem from the floor, and I take this on advice from the Chief Whip, I can also second the minutes because I was present. Thank you very much. Honourable members, with that, thank you for your attendance today and thank you for your participation. Once again, appreciation from myself for making sure that our meetings are always constructive. And thank you very much to our committee staff for always ensuring that we have all the paperwork ready for all our meetings prior to the meetings. With that, thank you very much. Enjoy the rest of your day. This meeting is now adjourned. Thank you.